Let's take a look at job announcements from an employment law perspective. Typically, an early step in the recruitment process is to write a job announcement. These documents announce the availability of a job, describe the job and its requirements, and tell prospective applicants what they must do to apply. The documents are then printed in newspapers or professional magazines, posted on bulletin boards or on the internet, or otherwise made available for inspection. To comply with anti-discrimination laws, the clear requirement is that the wording of a job announcement must be neutral. A neutral message does not express or imply a preference for some protected class group over another. For example, terms such as young people and recent college grad may imply a preference for persons younger than the age of 40 and tend to discourage applicants from older workers. However, courts will consider whether such terms articulate requirements for a particular position or merely suggest groups of people who might be interested in employment. In a case challenging an employer's practice of recruiting college campuses, a federal appeals court rules that this practice is neutral and that the Age Discrimination in Employment Act does not permit disparate impact claims by applicants. Where job announcements are published is another matter. Employers are free to publish neutrally worded ads in publications that are targeted towards particular protected class groups, like a foreign language newspaper. However, if that is all the employer does to promote an employment opportunity, it is likely to produce discriminatory effects. Employers should use these outlets in conjunction with other media to reach a broader spectrum of employees. Employers with affirmative action plans often include job announcement language to the effect that applicants from women and minorities are especially encouraged. Such statements do not violate the neutrality principle. They are intended to address the reluctance that women and persons of color might have to pursue employment opportunities given the history of employment discrimination against members of these groups. They also signal that employers are aware of their legal responsibilities and do not intend to discriminate. Finally, although we've assumed that the employer has produced and disseminated a job announcement of some kind, this is not a foregone conclusion. Employers are under no specific legal requirement to do so, but when information is orally conveyed to a select few and denied to everyone else, the hiring process looks very suspect. Failure to post job information and make it available to broader audiences is a common complaint in discrimination cases.